Hi, I'm Julia Shear Kushner. I'm a member of the California Lawyers Association Litigation Section Committee on Appellate Courts, and I'm here with Danny Potter, Clerk Executive Officer of the California Court of Appeals Second District, to talk about remote oral argument. To start, at what point did the Second District make changes to oral argument practices in response to the pandemic, and what were those changes?
Well, on March 16th, this court issued an order suspending all in-person oral arguments and going to telephonic appearances for oral argument.
Okay. I know originally on the original order, it talks about video versus telephonic. The court decided to do telephonic only?
That is correct. We are moving toward video conference oral argument, but that's probably not going to be up and running in the Second District until we're keeping our fingers crossed for June.
Oh, excellent. How do litigants tell the court the information about their oral argument appearance, their phone numbers, and so on and so forth? When are notices sent, and how do people make choices?
Sure. So we made some edits to our standard calendar notice that go out typically 20 to 30 days in advance of the oral argument date itself. The edits that we made to those notices were to include a conference line and a participation code for the conference line. It did not give a choice because we weren't able to do the video at this time. So it's only a telephonic option at this point.
Excellent. Is it possible to estimate how long remote only argument is going to last? May, June, July, August?
I would venture to say that certainly we're not going to change anything until the governor and the mayor's orders of stay safe at home orders are lifted. We're not going to open up our courtroom to litigants or to attorneys if those orders are still in place.
Gotcha. My next question is, do you anticipate any changes to how remote arguments are conducted? You've talked about going to video, hopefully in June. Is there any information about what's going on with the video conferencing and how that will work?
Well, we, of course, are following the example of the California Supreme Court. I think we all saw their argument a couple of weeks ago where they used, I believe it was a Blue Jean technology or solution to conduct oral arguments. And so we're following those footsteps. Right now we have IT staff up and down the state that are gearing up to make this happen.
Great. How, if at all, can the public view or hear remote oral argument? Or can they go to the courthouse to observe or hear the recording of the oral argument?
Sure. So at this point, if we received a request by the public to listen to oral argument, we can make that accommodation at the clerk's office via a speakerphone, so they can listen in.
Oh, excellent.
There is no entry into the courtroom. No one's in the courtroom. But a litigant or a member of the bar could always obtain a audio recording of the argument after argument is done.
Great. So either people can get it and can make the advance request, or they can get the recording after the fact.
Correct.
Do you anticipate video appearances being easier or harder to set up and manage for either the lawyers or for the court?
Sure. I mean, I think that when we have our first run, I'm sure that it'll be a little bit more cumbersome, or it'll appear early on until we can get used to using that technology. We found that with audio recording or audio appearances, the first couple of times there were some hiccups and dropped calls and what have you, but it seems to be running a lot smoother the more that we use the technology, and I imagine that experience will be the same for video.
Can you tell us a little bit about what arguing by teleconference has been like for the justices, for the lawyers and parties, and what they're hearing? Does everyone call in at the beginning and wait their turn and listening to others? What's the experience like? Sure.
The experience initially was, again, a little bit difficult with drop calls and what have you, and then getting used to everyone being on the telephone. Certainly the quality of the audio is not as good as if you were present in the courtroom listening to live argument. But we suspect that when we go to video, very much of the same will occur initially. And as we continue to use and become familiar with the technology of video oral argument, I think that that's going to be a smooth process, and I think we'll get used to it.
What have you found that the lawyers can do to help present themselves best on the phone, or what do you imagine will be helpful when you do go to video for them? So can you speak to us about both, either what's going on the phone now, what their best practices will be for the phone now, and what you anticipate you'll be looking forward to them doing once the cameras are there?
I think pretty much all of my presiding justices, as you know, we have 8 divisions in the 2nd District.
Mm-hmm.
Each of the presiding justices is actually going through a script, if you will, of instructions prior to commencing with argument. So just advising the lawyers to not speak over each other, that if a lawyer is presenting argument and hears something, that they should stop, because maybe it's a justice trying to ask a question. So not speaking over anyone. If you're not the one arguing, maybe you're the opposing counsel, have your phone on mute just to drown out background noises.
Mm-hmm.
And avoid using speakerphones. And we have found that landlines seem to be have a stronger, clearer connection than mobile phones.
Mm-hmm. And you talked about initial hiccups. Have there been any lawyers being disconnected while arguing or waiting to argue? And how, either if there have been, how was that handled? And or in the future, if that is to happen, do you have any suggestions for an attorney if they were to be disconnected, how they should handle that?
Sure. We did experience that. In fact, we actually on one argument lost the justice.
Oh goodness.
But what we've done is we do have a clerk operating the audio equipment and the conference call equipment. So if it becomes known that an attorney or a justice has dropped off the call, either via email, text, the clerk gets alerted to that, and then we'll reach back out to the attorney or the justice and bring them back into the call.
Great. Is the court continuing any arguments in the hopes of having them in person? Have there been any noticeable changes in any requests to continue argument?
Certainly, we have probably seen an uptick in continuance requests. I think a couple of divisions have actually postponed argument for the last month or two, but hopefully will be with the onset of video conferencing, those divisions will want to proceed with oral arguments.
Mm-hmm. Have there been any specific requests to wait to appear in person?
There have been.
If you can speak to that.
There have been. The court is really encouraging counsel to participate via currently a conference call argument. We don't want to have cases stack up and not get processed, not get filed.
Absolutely. Absolutely. Will these COVID-related changes to argument currently, do you think, have any lasting impacts on the way the 2nd District conducts oral argument going forward?
I think absolutely it will. I think that especially once we see the video technology and get used to that, I absolutely think that moving forward, remote oral argument via video conference is going to be something. It won't become the norm. We'll get back into courtrooms, but I think that it'll be a very viable option for as needed in the future.
I've been hearing that a lot. All right, one last question. Any parting thoughts about remote argument for our lawyers?
Believe it or not, it works.
Great, thank you so much. That's all I have. Have a good one. We'll see you virtually on video in June.
Very good. Thank you.